unpack this conversation, we're now joined by Lawson Naidoo, Counsel for the Advancement of the South African Constitution, and he is the Executive Secretary. Lawson, thank you so much for joining us here on the late edition. Of course, we saw the arguments taking place at the Constitutional Court on day one. What do you make of those, the court matters today in the Con Court in that regard?
Yes, thank you and good evening. Well, it was a long day in the Constitutional Court today, and as you said, it will continue tomorrow. There are two separate applications brought by the Independent Candidates Association and the One South Africa Movement, who are each challenging different aspects of the Electoral Amendment Act. Argument today focused primarily on the split of votes, as you highlighted, between the regional seats and the compensatory seats for the National Assembly. The split in the bill is 200 regional seats and 200 compensatory seats. And the argument for that is that it provides for proportionality in the outcome of the election, which is a constitutional requirement. The argument from the ICA was that a split of 350 regional seats and 50 compensatory seats would also produce a proportional result, and they preferred that option. Ultimately, I think it was the argument came down to that both options were indeed rational and constitutional. The one proposed by the ICA may better serve the interests of independent candidates, but having a preference of one system over the other does not necessarily mean the intervention of the court would be required to declare that 200-200 split has either been irrational or unconstitutional. So there were some tough questions that were asked from the bench of the counsel for the ICA, Mr. Madonsela and Mr. Duval. But obviously we'll have to wait and see how the court at the end of the day weighs up the arguments that were presented to it today. And then the other case involving the One South Africa Movement focused, as you say, on the signature requirements for eligibility to contest elections, both for independent candidates as well as for parties that are not currently represented in any of the legislatures.
And Lawson, what are your thoughts when it comes to the arguments being presented in court, especially looking at the seat allocation, the 200 out of 400 seats for independent candidates? When you weigh in on that argument, do you think that it was irrational when it comes to this new Electoral Amendment Act?
Well, on the first point of the 200-200 split, I certainly don't think so. In fact, CASAC had proposed, in line with what was recommended by the minister's own advisory committee, a hybrid model whereby there would be 200 single-member constituencies with a 200 compensatory list. So the split would be the same, and therefore I think that's an eminently rational way of proceeding. The unfortunate thing about this case, and it's not about the case, it's about what Parliament did, is that rather than try and change the system to some sort of constituency-based system, which would be the easiest and fairest way to accommodate independent candidates in our electoral system, they opted instead for what is called the minimalist approach and simply tweaked the current electoral system, the party list system that we've become accustomed to. And that has given rise to the anomalies that we see being challenged in the court today. So I think had Parliament done a better job of amending the legislation, accepting, as I do, that they were under significant time constraints to do so. But I think it does expose the fact that the scheme in the Act for the next year's elections is far from ideal. And the one thing that needs to be welcomed is the Parliament's late recognition of that fact, and therefore establishing an electoral reform consultation panel, which would make further recommendations for hopefully a complete overhaul of the electoral system ahead of the 2029 elections. So at the moment, what has been contested in court today and tomorrow is really, can we tweak this current system with a minimum of fuss in order to ensure that there are free and fair elections in South Africa next year?
And what does this actually say about the elections? I mean, we are a couple of months away from the 2024 elections, and it will be the first time where we are seeing the independent candidates, contesting on a national and provincial level. Where does this matter then put the elections for 2024?
Well, I think, we'll have to await the determination of the Constitutional Court on today's hearing, and hopefully that will be delivered quite soon. But what I think we all require is finality in terms of the electoral system that we'll be using next year. That will be in the interests of the voters, of independent candidates, political parties, and perhaps most importantly of all, of the Electoral Commission, who need to plan and manage those elections next year. The decisions that come out of the Constitutional Court will have an impact on the kind of ballot paper that's required. Those need to go into production months in advance of the election. Certainly preparations need to be started as soon as possible. So certainty is important. And I think whilst the system that the amendment bill provides is far from perfect and is in fact rather problematic in many more respects than has in fact been highlighted by these applications. It is inappropriate to accommodate independent candidates, but whether that stretches to it being declared unconstitutional, I'm not so sure. And I think, as you highlighted again in that clip earlier, the concern of the court is about overreach and is about transgressing the separation of powers, and really what the applicants are asking the court to do is to tweak the electoral system, something that the Constitution leaves in the hands of of Parliament itself. And Parliament's done its job, a far from perfect job, as I say, but it's done its job and provided us with a framework for the electoral system.
And what are your expectations for tomorrow's arguments on the final day of the matter?
Well, we heard the beginning of arguments on the signature requirement, as well as what happens when an independent candidate vacates their seat. The arguments on that will be rounded up tomorrow, and I expect that the case will be adjourned at around lunchtime tomorrow, if not earlier. And as I say, then the court is going to be under some pressure to deliver a judgment as soon as possible. They did hear this matter on an urgent basis. I think the court, and it was clear from their comments today, they're acutely aware of the urgency of this matter, of finalizing the electoral system for next year. So I'm hoping that we can expect a judgment sometime within the next few weeks. But the arguments have been presented, and it's really for the court to make a determination as to whether any of those objections that have been raised cross the bar of making them unconstitutional or irrational, and the court then having to intervene and set those aside. If it does do that, it's then going to have to determine what the appropriate remedy is, and whether the court then exercises its reading in powers to tweak the electoral system for next year's elections, because there's clearly no time for the matter to be deferred back to Parliament, or Parliament itself to fix any defects that the court may identify.
Certainly, the Constitutional Court will be under pressure to ensure that they come up with a judgment just before the 2024 elections. That is Lawson Naidoo. He is the Executive Secretary for Council for the Advancement of the South African Constitution.